very much for joining us. That's very much appreciated. So our webinar is on UAE and UK wills, guardianship, and UK inheritance tax today. And just before we really get started with this, there are just a couple of housekeeping bits and pieces I need to cover with you. The first is that hopefully you can see a Q&A box or a little toggle for that. So if you want to ask any questions, please do feel free to pop them into that Q&A box. And we're going to leave a little bit of time at the end to see if we can answer some of those questions for you. The other thing to say is if you would like a copy of today's slides, more than happy to pass those on to you. You have our contact details, but I'll be popping up a slide at the end just to remind you of how you can get in touch and ask for a copy of those slides for you. Okay, thank you very much. So let's get cracking. Oh, there we go. All right. So we're really, really pleased to be joined by Cynthia Trench today. She's going to introduce herself to you a little bit later on, but she's the principal partner of Trench and Associates in Dubai. We at the Fry Group have collaborated with Trench and Associates in our service offerings for about a year now, and we're really pleased to be able to present a joint webinar to offer both legal and a financial overview as well. To introduce myself to you, of course, I'm Peter Webb and I'm the International Tax Manager for the Fry Group. I've been with the Fry Group for just over 6 years now, and at the moment I'm based in Singapore, and that's where I'm talking to you from today. I know that some of you are familiar with the Fry Group, but some are not, so a brief introduction before we get started. So the Fry Group was established more than 120 years ago. And since then, we've helped thousands of people around the world and across the generations. And today we have 8 offices around the world. So we can offer maybe that global perspective. Our services fall into 3 core areas of financial planning. We think about tax, we think about estates, and we think about investments. And of course, we're thinking about tax today. Our teams work together across these areas and across countries to create the right balance for each client. And our core purpose is to create financial freedom for our clients. That's what we're about. I understand that means many different things to many different people. So we take the time to find out what is important to you, and we structure your finances around your goals. Okay, all right, that's enough of an introduction. So let's actually talk about what we're going to look at today. So this is the main event, and the agenda there is what we're going to cover. What I would say to you really importantly at this point, do not take any action on today's presentation without seeking specific advice for your personal circumstances. I'm going to be talking through a lot of stuff in quite general terms for you. Okay, so I'm going to start with UK wills, just some brief comments on UK wills. At the Fry Group, we have a great team, our Estates and Trust team, who can help you with your UK wills. And I think one of the things we've really enjoyed is working with Cynthia to make sure the UK will actually ties up really, really well with that DIFC will as well. Okay. So why should you have a will? There are some great reasons why you should have a UK will or have a will on this slide. Personally, I would mention around about 20 years ago, I inherited a little tortoiseshell cat called Kitty from my great aunt. And Kitty was a fantastic little, lovely little cat. And I think, you know, what would have happened to Kitty if she hadn't been left to me in my great aunt's will? I hate to think. It's a completely true story. One of the things that a will can do is help you to minimize inheritance tax, just to pick up on just another point on that slide. Okay, so what happens if you don't have a will? I think that's absolutely a great question. We're going to be doing a lot of talking, but you just can't sit back and listen to us. We have a question or two for you. And the first of those questions is going to pop up on your screen now. And the question I want to ask you is what percentage of UK adults who need a will actually have one? So you've got some multiple choice there, and I'll just give you a few seconds to answer that. So yeah, we're getting some interesting responses on this. So how many of you have voted? I think we're pretty much there, actually. We're not far off at all. So yeah, I think we're going to close the polling there, and we'll show you those results. So 82% of you got absolutely the right answer. So we feel that of the UK adults who need a will, only 46% of those actually have a will. So more than half of the adults who need a UK will don't actually have one. And there can be some quite unexpected consequences for not having a will. Okay, one of those perhaps is that you're in a civil partner. If you're not married, just to take one example, and you intend your partner to actually receive all of your assets, but if you haven't got a will written, that's not going to happen. And perhaps children can inherit, and that can lead to an unexpected inheritance tax charge. As we go through the presentation, you'll see the destination of your assets when you pass away has a huge bearing on when and if you're actually going to pay inheritance tax. Okay, wills for non-UK residents, which I'm guessing is pretty much all of you out there listening to me just now. And this is really, really tricky. It's going to depend very much on your personal circumstances. You're going to have to think about the laws governing estates in both your home country, your country of residence, and countries where you have property. That all needs to be considered. Each country has its own laws to govern the distribution and taxation of an estate. If you own assets in more than one country, you may well require several wills. And those wills need to work alongside each other and written really, really carefully. It's entirely possible that you write a will in one jurisdiction and it actually revokes all of the other wills you've written anywhere else.
In fact, that's where I want to come in. We have DIFC now since June 2019, allowing people to include their worldwide assets in their DIFC wills. And unfortunately, there's a lot of people who do not understand that you can't just say, especially if you are a UK national or UK domicile, oh, I'll just stick my property in the UK in my DIFC will. You can't do that, because there's something called lex loci or lex situs, where the law of the country where your assets are located would govern the distribution of that asset. And sometimes, unfortunately, unwittingly, let's say I'm from Hong Kong and I've got a Hong Kong will, and after I've entered into my DIFC will, I then have a Hong Kong will that says, oh, my Hong Kong will revoke all my wills worldwide. Then I have a lot of problems, because then my DIFC will would get revoked, which is your point there.
Yeah, absolutely. Thank you, Cynthia. And when we work with Cynthia, we are very, very careful on these points. Okay, all right, moving on from wills, which we've covered very, very briefly. We're going to move on to inheritance tax. Let's get cracking with this. Okay. So I think of inheritance tax as perhaps the most punitive and pernicious weapon in HM Revenue's arsenal. I'm getting quite passionate about that. In many cases, it's a tax on income and gains that have already been taxed through your lives. Now, we're going to talk about a couple called Darren and Daisy. And by the time I finish speaking, you're going to be completely fed up of hearing about Darren and Daisy, but we're going to tell their story. So Darren and Daisy are married, and their wills leave everything to each other. We call this mirror wills. They've never lived outside of the UK. Darren dies and leaves everything to Daisy. So when Darren dies and leaves everything to Daisy, there is no inheritance tax to pay. it is only when Daisy dies, it is only when the second spouse dies that that inheritance tax is charged in this case. However, when Daisy passes away, that is the point the inheritance tax is charged. And what if that estate that Daisy has in her hands is worth £3.15 million? So what do you think the inheritance tax charge would be on that? So Daisy has an estate of £3.15 million. We're just going to take a little bit of a guess at how much inheritance tax she would actually pay on that. I'm not going to answer the question, you are. So that multiple choice answer will be popping up on your screens right now. Oh, some really interesting answers coming in, actually. Yeah, it's that inheritance tax charge is 40%. It's a very, very high charge indeed. Okay, I think a couple of more people are still having a bit of a punt at this. Okay, I think we'll probably close the polling there and just see how we did. And if we share those results, okay. All right, so some of you went for £800,000. Going to say now that's wishful thinking. Some of you went for £900,000, just a few of you. That's still wishful thinking. Most of you actually got this right. £3.15 million. That inheritance tax bill could be £1 million that is going to go to Rishi Sunak rather than your intended beneficiaries. That's quite shocking. Okay, let's just close that down. Okay, so moving on, why is your domicile status important? So for UK tax purposes, you have two tax statuses that determine your liability to UK tax. You have your residence status. You assess that each year under the statutory residence test. And I can see some people out there who I've been helping with that exercise. The other status you have is what we call your domicile status. Your domicile status is determined very much over the longer term, over the course of your lifetime. I'm going to make a very general comment. You usually acquire a domicile of origin from your father when you're born, and that's hard to change. Not impossible, it is hard to change though. I've said it's a very general comment. Matters can be extremely complex, so please do speak to us if you have any doubts about your domicile status. But why do we care? Why do we care about your domicile status? Your domicile status determines your liability to UK inheritance tax. If you're UK domiciled, your exposure to UK inheritance tax is on your worldwide assets. If you're not UK domiciled, your exposure is limited to UK assets only. Hopefully you could see that that non-domicile status could be a huge advantage to you for inheritance tax planning. But once a non-domicile comes to the UK, that really helpful non-UK domicile status has a shelf life. And usually it expires at the latest 15 out of 20 years of UK residence. There's much planning that we can help you with before you become deemed to be UK domiciled by spending time in the UK. Okay, so moving on a little. There are many, many different strategies that you can use to reduce your exposure to UK inheritance tax. And in the limited time we have, I'm just going to focus on a couple of those. One of them is making gifts of assets to reduce your chargeable estate. And the other thing that we're going to have a little chat about is making sure you're using all of the available allowances that there are to reduce inheritance tax too. Okay, so gifts in life to other people is a really simple way to reduce your inheritance tax bill. So we're going to pick up with Daisy and Darren again. So as you remember, Darren has sadly passed away. He's left everything to Daisy. No inheritance tax was payable when Darren died, but Daisy now realizes there's going to be a huge IHT bill when she dies, it was £1 million. So to try and reduce that, she gives one of her buy-to-let properties that she has to her daughter. Her daughter's called Diana. She has to pay capital gains tax on that gift to Diana. And she can no longer enjoy the income from that property or make use of it. And Diana, her daughter, is now free to do whatever she wants with that property. Now, as long as Daisy survives 7 years from making that gift, the value of the property will not be charged to inheritance tax, provided that all of the conditions on that unconditional gift have actually been met. Okay, so supposing that property was worth £500,000, by making that unconditional gift to Diana, Daisy has saved £200,000 in inheritance tax. It's a really simple way of actually reducing your exposure to UK inheritance tax. Okay, what about gifts between spouses? So when we thought of Darren and Daisy, they're both UK domiciled. So any gifts made between them in life and in death are exempt from inheritance tax. Now I need to introduce Nigel and Nancy. Nigel and Nancy are non-UK domiciled. So you see what I did there? Darren and Daisy, D, domiciled. Nigel and Nancy, N, non-domiciled. Okay. So with Nigel and Nancy, again, they can pass assets between them in life and in death with no inheritance tax charge because they share the same domicile status. But there is a little bit of caution needed. So if one of the spouses, say if Nigel, had become UK domiciled because of the length of time it's spent in the UK, but Nancy remained non-UK domiciled, then the amount that Nigel can pass to Nancy is limited. We're looking at £325,000 in his lifetime and £325,000 on death. So in that lifetime, £325,000, anything above that, Nigel needs to survive 7 years for there to be no inheritance tax on the gift to his wife. Later on, we're going to talk about a little strategy that can help alleviate this problem of passing assets from a UK domiciled spouse to a non-UK domiciled spouse. One thing to think about, though, is what if Nigel is UK domiciled, but Nancy retains that non-domicile status? Nancy's overseas assets are not within the charge to inheritance tax. So if Nancy passes away and passes all of her assets to Nigel, all of those assets that were exempt from inheritance tax because they're overseas are now in Nigel's hands, and Nigel's exposed to inheritance tax on his worldwide assets. So is that the right thing to do? Should Nancy pass her exempt assets into a chargeable estate? Should she give them to Nigel? Or is there another destination for those assets if Nancy was to pass away first? And there, hopefully, you can see how a little bit of inheritance tax planning would tie up with how a will is actually written as well. Okay, this is a great piece of inheritance tax planning because it's so simple. You're able to make gifts that are immediately exempt from inheritance tax with no need to survive 7 years from making that gift. There are conditions to be met. We call this your normal gifts out of your income or gifts out of spare income. So these gifts form a part of your normal income. It's a regular gift. It's made, I think the point that you need to make is made out of your genuinely spare income, and it doesn't cause a reduction in your standard of living. Those gifts are made regularly and they're recorded. It does require good record keeping. What I like about this is that regular gift you make is immediately outside of your estate, and it doesn't take much planning. It just needs good record record keeping. It's something that you could set up this afternoon if you wanted to. And we can talk to you about this. Okay, so we've had a little bit of a think about gifts. I want to move on and just think about some of those inheritance tax allowances. So each year, on a use it or lose it basis, you have an inheritance tax exemption, £3,000. You can make a gift of £3,000 each year and it's exempt from inheritance tax. You don't have to wait 7 years. Now that £3,000 annual allowance, it does carry forward for 1 year only. So if you haven't used it in 1 year, you can carry it forward to the next year. And perhaps in that next year, you can make £6,000 free of inheritance tax. And there's a small gift exemption as well. And you can make any number of gifts in a year, each up to £250, but you can't make gifts to the same person. It has to be different individuals you make that gift to. And those small gifts are, again, completely exempt from inheritance tax. Okay, so going back to Daisy and Darren's daughter, Diana, hopefully you've remembered her. Now, Diana is actually getting married. So Darren can make a gift of £5,000, completely free of inheritance tax, immediately exempt. Daisy can do the same. And if they haven't used their annual allowances, either in that year or the year before, there's actually £22,000 that they could actually give, which is going to be immediately exempt from inheritance tax on the occasion of Daisy's wedding. Sorry, Diana's wedding, getting myself confused there. But £22,000, that would save you £8,800 in inheritance tax, potentially. Generally, the gifts need to be made or at least promised before the marriage or civil partnership actually takes place. So another allowance that you actually have, we call this your nil rate band. And usually this is the maximum amount that can pass free of inheritance tax, currently £325,000. So just to pick up on one point on this. So sadly, Darren has died. Do you remember this? And he leaves everything to Daisy. There was no inheritance tax payable on Darren's death. This is because it's a UK person to a UK person. Darren didn't need to use his nil rate band. So is that nil rate band lost? No. The unused nil rate band now passes to Daisy. So when Daisy passes away, there are still 2 nil rate bands that reduce the inheritance tax. Okay, I'm just going to very briefly mention this. So we're really now delving into the very dark arts of inheritance tax planning. This is where it gets really, really serious. So we mentioned there's a problem if Nigel, who's UK domiciled, leaves assets to Nancy, who's not UK domiciled, because he can only leave £325,000 and everything above that is going to be charged at 40%. To stop that happening, Nancy can actually elect to be UK domiciled. What that means is that she receives all of Nigel's assets over and above £325,000 with no inheritance tax. That's the good news. The bad news is she's then elected to be UK domiciled and her worldwide estate is then firmly within the realm of UK inheritance tax. If she leaves the UK for long enough, that election for UK domicile then falls away. Okay, so there is a little bit more you can add to £325,000. The details are on the slide there, and the additional allowance you have is for the value of passing on your main residence to your direct lineal descendants. Okay, all right. So at this point, I'm going to hand over to Cynthia, who's going to pick up on UAE wills and guardianship.
Thank you. I'm going to now click share screen.
Yes.
Okay. And there you go. So can we see each other? Yeah. So basically, what we have here is, of course, wills for the UAE, which, as you may know, has only really started since 2015. And by the way, before we start, I'd better introduce myself a little bit. And I have been here for a long time. Since 1989, I have actually been here in Dubai for 31 years. And Trench & Associates been around for over 26 years. So having been here for so long, we've seen obviously the country grown from a sort of like a village atmosphere to the city that it is now. But most importantly, you will see that the country has now developed its wills, because prior to 2015 and DIFC, you have the problem where a lot of will writers came into the country and they started drawing up wills that were unenforceable. So I just want to, start with the first slide, which is what options do you really have as an expatriate? And I'm afraid for those who are who are Muslims, I am not covering your area today, other than to share with the non-Muslims what can happen under Sharia. But you're very welcome, those who are Muslims, to contact me afterwards to look at your estate planning. So what options do you have? You have 4 options really, or 2 mainly. One is to succumb to Sharia, or have your will properly registered. And I'll come to the registration of wills afterwards. A lot of people hear about Sharia, especially those people who have come to Dubai recently. I've heard of all sorts of rumors that, ooh, your brother-in-law is going to grab all of your assets upon your husband's death or your spouse's death. And if both you and your spouse were to unfortunately pass away, then the government will come and grab your kids. And I'm afraid, or fortunately, those rumors are actually untrue. We have a very important slide, which is really a little example as to what Sharia is. And before that, I just want to go through the tenets of law, which fortunately for us is not a lot, just 3 main articles, and not terribly boring. The first article, which a lot of the will writers use, is basically to say that inheritance is governed by the law of the deceased at the time of his death, which means that if you have a home will, it should be all right. Or why don't you just go to the Dubai notary and add a clause in there stating Article 17.1 says that your will can be governed by the law of your home country, which if it is Darren, it'll be English law. But unfortunately, they don't actually tell people about Article 17.5, which is a very important article because it says that the law of the UAE shall apply to wills that are made by expatriates, not aliens, disposing of their real estate in the UAE. So you've got a conflict of laws there. One is, on the one hand, you've got home law governing your estate, apparently, and on the other hand, you've got the laws of UAE. So before the 2015 regulations of the DIFC, you have a conundrum, because furthermore, there was Article 242, which stated that if a will has got a condition which is contrary to Islamic tenets or intents, then the condition will be void, which in most cases would be, because if you were to give all of your assets to, let's say, your spouse, that in itself would make the will void. So before 2015, you had this horrendous situation where people were running around with wills that were unenforceable. They would go to the personal status court, and they would go to the Sharia personal status court, obviously manned by Sharia judges. And the Sharia judges would say, thank you very much, but we are going to abide by Islamic rules, and we will therefore adjudge that the mandated provisions would govern your distribution of your estate. And then what you find is that you would find an advocate lurking in the corridors of the court going, we can help you. But they didn't tell you at the time that it will cost you 50 to 100 and sometimes even 200,000 dirhams to appeal against that Sharia court order. Now, it seems, as far as I'm concerned, it seems that Sharia, or at least a lot of people would think that Sharia is a bit of a nightmare. But you have to understand that if your family structure is actually quite simple, it could also work. Now, can we actually have a live case here? Peter, tell me a little bit about your family, other than your little cat. What family members do you have? Oh, I can't hear you, Peter.
There we are. It's very, very simple indeed. I have my wife, Carol. We don't have any children. We have 2 cats.
And parents, are your parents alive?
I have, my mother is alive. Carol's parents are both dead.
And what about siblings?
I have a brother and a sister. Carol has 2 sisters.
Okay, so in your case, your siblings actually come into play under Sharia, okay, which in a lot of cases, most people would say, oh, I don't want that. I definitely don't want my siblings involved. So let's have a look at this sort of example where you have a husband and wife and they have parents. In this case, both of their parents are alive and they have a son and a daughter. So bless their heart, they've got a really beautiful family structure here. So they have a joint property in Arabian ranches in Dubai, and they have a joint bank account. The usual bog standard Jumeirah family or Arabian ranches family structure. What happens if, unfortunately, the husband were to pass away? His parents in Sharia, for the assets in the UAE anyway, his parents would actually take the benefit of 1/6 of his assets in the UAE. And if the wife were to pass away, her parents would get 1/6. And the husband will get 1/4 of her joint asset, which in the UAE, it's actually divided into 50%. So the husband would get 1/4 of the 50%, whereas the wife would get 1/8. So you can imagine a lot of very unhappy spouses out there who, instead of being the 100% beneficiary under will, they're only 1/8 beneficiary or an heir to the estate. Whereas the lion's share, strangely enough, actually goes to the children, the boy taking 2 parts and the girl taking 1 part of the remainder. So just a very, very quick story. I always tell the story for those people who have attended my webinars or seminars. I see that Graham Martin's around. You're probably bored of hearing about this story, but here you go. So there's this couple who finished walking along on a beautiful November day, not like now, muggy June day, along the El Awir Flamingo Park. And it was a crisp sunny day. And unfortunately, when they just got into the car, a truck lost its brakes and ran into the car. The wife was terribly injured and got into a coma and died shortly thereafter. And the bereaved husband, fortunately, he recovered and he went back home to the UK, both UK nationals. And the wife actually had a will. The husband got the grant of probate. And because the estate wasn't very large, he got it relatively quickly. And he sent it to me, the grant, and also power of attorney. I helped him with drafting that, all notarized and legalized, the grant of probate and the power of attorney. And he said, right, can you please go and see whether you can get the bank account liquidated under the name of my deceased wife. His name was Michael, and I said, Michael, yes, I'll try to do that. Are there anyone else in the family? Are there any other family members? And he said, yes, my wife's parents. So I said, okay, well, at that stage it was 2007, and I said, well, unfortunately, you would find that the Sharia court will deem that they are entitled. And he said, well, see what you can do. So I got the Sharia succession certificate, and the parents got their percentage, and Michael also got his percentage. There's no children, so it's only the three of them. And because the father was alive at that point, the siblings did not come into play. The presence of either father or son would exclude siblings in a family structure. So I went to Michael and said, I'm sorry, but here's your Sharia succession certificate. And he said, oh, I'm not very happy about that. Can you please contact my parents-in-law and ask them whether they would give up their share? And I thought, this is rather strange. Why don't you do that? But anyway, so I did that. And of course, I think most of us could guess, and this is where the polling should have started, guess that the answer from the parents-in-law was basically no. The moral of the story is that, Peter, please remember, be nice to your in-laws. So, but that gave me an idea. I thought, oh, what if I managed to have the in-laws or the family members all fortunately, amicably involved, and they're very friendly with each other, and they're willing to waive their rights. So after this episode with Michael, ever since then, I have started with doing more Sharia inheritance, where people don't have wills, or they have an unenforceable wills. They have no choice but to go under Sharia upon their unfortunate demise. And the surviving spouse would come to me and I said, look, why don't you look at having a Sharia power of attorney? And you would find that you could do that if you have a fairly simple family structure. And you could use a Sharia power of attorney where the heirs would waive their rights to a joint property, to cars, to even termination benefits that you might have. A lot of people forget that's actually an asset in the UAE. But also what Peter and I are trying to help you do today is to think about not only having wills done, but to do proper estate planning. And think about having a individual bank accounts open instead of just joint bank accounts, because in a civil code country, joint bank accounts are frozen. Okay, ladies and gentlemen, for those people who don't know, please, please open your individual bank accounts and put not too much money in there if you can, because these days, US dollars, sterling, whatever it is, don't attract too much interest anyway. So put the bulk of your readies, your cash, abroad in an offshore bank account. There's many different types of structures. I'm sure the Fry Group could help you with that, where you can put your assets into a fund, into insurance type related fund, and that would be offshore. And in an offshore situation, in a common law country, joint bank accounts are actually able to be survived, to be immediately distributed or owned by the surviving spouse automatically, unlike a civil code country. So just to repeat, common law jurisdiction, please open your bank accounts there. For those people who have businesses, you might like to think about putting your assets under a particular structure. These days, there's many structures that we can talk about. You can have it under an ADGM SPV. You can have a holding company under JAFSA. You can have a holding company under DIFC. And for Muslim, just a quick one, you could have a foundation to take your interests outside of the Sharia premise. But of course, there are those of you like Peter, for example, who do not want their siblings in the Sharia scenario to take distribution of your estate. And furthermore, especially now during the COVID pandemic situation, a lot of you are very worried as to what will happen if both of the parents were to unfortunately die. Of course, as I've just said, the government doesn't come in here and grab the children and put them into an orphanage. There's no such thing as an orphanage here. They do have protected custody, but what you can do instead is have a will done. And no matter what people would say the only jurisdiction that I would recommend in the UAE is the DIFC. Not only is it a jurisdiction which has promulgated a proper system and a proper set of legislation concerning wills, which is about that thick, and you can download it from difcwills.ae. Not only is it that, but most importantly, it is a common law jurisdiction. And for those people who don't know, difference between civil code countries, which is basically the rest of the UAE, and common law jurisdiction, which is UK, for example, Hong Kong, India, US, Canada, and fortunately DIFC and the HGM. DIFC is a common law jurisdiction where all the court judgments are of certainty, and they are bound by what we call stare decisis. And the lower courts are bound by the superior courts, and the courts which are the first case that is done on a particular subject will bind any of the future courts. So the judges cannot veer from this legislation or the court judgments by interpreting willy-nilly a particular legislation on their own accord, which unfortunately happens outside of the DIFC in the Dubai courts. So that is why when you have the Dubai notary wills or the Abu Dhabi registry wills, hello, you're in civil code jurisdiction. How do you know that they will be upheld properly in that system? Furthermore, the DIFC court's probate cases are now publicly listed online. You can actually inspect them and see who has unfortunately died and have registered their grants of probate. And it has been tested on more than 24 situations or occasions. And we have dealt with over 7 of these cases. And on the average, this is a very popular question that people ask me. On the average, I would say it takes about 3 to 6 months for a probate case to be done and dusted. And Peter, I think a lot of people are under the misguided belief that probate would be done like this in England or in a more civilized jurisdiction. How long does it usually take? Let's say for £500,000 to £1 million, small estate.
Yeah, we're probably looking at about 9 months to get that all sorted out and distributed to the beneficiaries.
And why is that?
It just takes time. It just, the estate has to be administered. Whoever's doing that needs to be absolutely certain they haven't missed any liabilities. They're going to wait some time to make sure all the outstanding bills come in. They need to understand that they've identified all of the beneficiaries, and they need to also get in place all of the authority to contact all of the different entities that actually hold assets for the deceased. It all takes time. And if there isn't a will in place, that actually makes the process even longer. Exactly.
And of course, this is when our very lovable Inland Revenue Department start rubbing their hands and say, right, we're going to look at your assets very carefully and the value in order to tax you. Whereas here, as you know, there's no tax. So there's only a lump sum charge on probate at the DIFC courts, 5,500 dirhams. And they do not levy it on the percentage or the value of the asset at all. And the only, if I may say, the only added expense would be lawyers. And if you have somebody like myself who knows what they're doing, and of course it's much faster and therefore cheaper. But as I said, on the average it's 3 to 6 months. It's really fast at the land department, really fast if you want to transfer a car, but as you can imagine, banks are very slow because they love sitting on your money. And sorry, there you go. And a lot of people, as I said, keep on asking me, why is it that the Abu Dhabi and Dubai courts or the Dubai notary will is not good? And it's as ridiculous as, I don't know how many of my clients have shown up at my office with a Dubai notary will, which has been witnessed by one notary, by one person. And even as for the laws of your home country, that would not be valid, because Peter, how many witnesses do you need under English law?
You need two.
Exactly. So in fact, most common law jurisdictions, you would find that you need to. Just a quick comparison chart. Yes, the main disadvantage is the registration fees is very, very high for DIFC, but there are many different types of wills under DIFC now. And then Dubai courts or Dubai notary, don't be fooled. They do look at the value of your asset when you put a specific property in your will, and they will charge a percentage of that asset. And Abu Dhabi, yes, it's really, really cheap, 950 dirhams. But then there's added costs, for example, that you have to translate it into Arabic, and that you have to go to, obviously, Abu Dhabi to register a will. And I'm sorry, if you're going to try to protect your loved ones and your assets, go for the best and the only one that has certainty. As I mentioned earlier, there are many different types of wills now. You can go for the cheaper variety if you want to just cover property, or just cover your bank accounts, or just cover your business, one particular shareholding in a company, for example. Or you want to have a guardianship will to provide for the care and custody of your children. And just talking about guardianship, they try to stick a little bit in accordance with Sharia, or at least not go against it. And they don't want to make Abu Dhabi angry, so they only provide for those minors who are habitually resident in Dubai. And they do allow you, which is really advantageous, to have interim guardians as well as permanent guardians. Interim being the ones who are resident here and can take your children into temporary custody, or can take your children and bring them abroad to the permanent guardians. You can imagine how advantageous that is, where the interim guardian shows up at the airport, especially now being so strict, with the court order saying that they are guardians to help with bringing the children abroad. And one of the best things about these guardianship provisions is that if you're a single mother, all you have to do is to show that you have a court order or no objection letter, or if unfortunately your husband has died, a death certificate. Whereas under the Dubai courts regime, you cannot have a guardianship, a guardian's actually appointed if you are a single mother. So that's it for me in terms of DIFC wills and Sharia. Peter, do you have any questions? I don't have polling, I'm afraid. I'm not as organized.
No, Cynthia, as usual, that's been absolutely fantastic. And it makes me very, I'm going to make a slightly odd comment. It makes me very grateful that actually I'm in Singapore rather than in Dubai. I had the chance to come and live in Dubai if I wanted to, or Singapore. For many reasons, I chose Singapore, but I do like Dubai. Just glad I'm not there and these aren't issues for me, because I would need to be speaking to Cynthia to get all of this sorted out for me, that's for certain. Yeah. Okay, all right. So if I just grab that, well, Cynthia, do you just want to keep control and you can run through the slides? So we've got to the wrapping up portion of the webinar. So thank you very, very much for bearing with us through this. I hope you've actually found this really useful. What I would say is that we want to spend a little bit of time just talking about some questions, see if we can help you with one or two questions. So Cynthia, if you click onto the next slide, questions, there we go. All right, so let's have a look and see what questions we actually have. I always find this quite exciting, actually. I tend to get a little bit too enthusiastic. So apologies.
Oh, so you have one. Why don't you take care of Jonathan and I'll take care of Sarabjit?
Okay. Do you want to go first?
Sarabjit actually says, hello, status of joint accounts in DIFC will. Can payout be made to the surviving joint holder? Yes, but only after you go through the grant of probate, because it's frozen. Joint accounts are frozen. They do not follow the common law jurisdiction where immediately the joint account holder morphs into the 100% survivor of the joint account. So the joint account is frozen, the property is frozen. You can't sell it, you can't transfer money out of the joint account. So it is a little bit of a nightmare. That's why, if you remember my earlier slide, I recommended you have individual bank accounts and to move your money outside.
Okay. All right.
Peter, do you want to take that one?
Yeah, so if I talk to Jonathan, Jonathan, thank you very much for your question. I'm assuming you say, my wife and I have different domiciles. I'm assuming one of you is actually a UK domicile. And if so, whatever the domicile situation, we will face the applicable IHT laws, which may not be more punitive than the UK. But there are a few regimes that are more punitive than the UK, but really not many, that's for certain. So yes, that's a very good point. You do need to understand what the estate duties are, what the inheritance tax is in any other relevant jurisdiction that might actually have a hold on you. So
can I punch it there?
Yes.
I think he's also asking about, do they need a local will if they own very little assets in the UAE? Jonathan, do remember that a lot of people forget that they do actually have things like termination benefits. I mean, I know that COVID-19, what termination benefits, a lot of people would say. But there's things that you may not have provided for or thought about. So it's very important to have the estate planning. But if you do have children, you might still like to consider having a DIFC will or guardianship provisions.
Okay, thanks, Cynthia. Thank you very much. I think just a further comment on the inheritance tax. If you have assets in the UK, no matter what your domicile status is, those assets will be within the charge to UK inheritance tax. So you could be UK non-resident, you could both be non-UK domiciles, but perhaps you've really liked the idea of investing in UK property. Well, by investing in UK property, you've actually also purchased an inheritance tax liability as well. So even with little connection to the UK, you still need to consider whether there is that inheritance tax charge for you. And of course, we at the Fry Group, we can certainly help you understand what the exposure is and how that exposure could be mitigated. It is part of our bread and butter. Okay, all right.
Two more questions for me.
I think
what age must children be in the UAE without needing a guardian? 21. But you don't need, obviously, a lot of children by the time they're 17, 18, they will have gone abroad to study, so they don't necessarily need to have a guardian. It's not mandatory, but if you do want it, they have to be under 21. And then would you need a will as a non-Muslim if you simply have a primary residence in Dubai? You don't need a will as a Muslim, as a non-Muslim, if you don't have any assets in the UAE. And it doesn't matter where your residence is. If you live abroad and you have an investment here, you can still have a DIFC will.
Okay. Thanks, Cynthia. And do we want to just move the slide on just one so we've got our contact details up as we're answering the questions? I'm getting a prompt in my ear for that.
Ah.
Okay, so it should be the that. There we go. There we go. All right then. I think that answers all of the questions that have popped up. I actually had a question, Cynthia. So if I've actually written wills through my life and I now have a DIFC will written, because listening to your advice, I think that's actually needed, what happens to all of those other wills that I've actually written?
Okay, so usually at that stage, I would say to my clients, please share them with me, especially if it's an English will or whichever one that's the country of domicile, or even a lot of my Indian clients. I would say, please share them with me, because you don't want a will to revoke each other. So if the will in UK, for example, or in Hong Kong or in India says it covers my worldwide assets, then you should do a codicil. to that will and say, oh, by the way, I've now done a DIFC will, and this will does not revoke the DIFC will, or the codicil does not do so. It should be read together with the DIFC will, and the DIFC will only covers the assets in the UAE, for example.
Okay, thank you very much for that. Okay, so I think, does that actually answer all? Oh, okay. I think there's one more question popped up, which is probably for you, Cynthia. You seem to be very popular. I'm struggling to find questions to answer for me, but this is from Maria. I don't know if you can see that one.
So your eldest daughter is 20, going to be 21 soon, I'm sure, and you've got 2 younger children. What happens if both of us parents were to pass away? Will they be able to leave the country with the older daughter? Yes and no. If it's unfortunately before your daughter turns 21, she cannot legally be a guardian. But however, children these days are allowed to travel abroad. I would, at the very least, Maria, not knowing what your nationality or your religion are, I would ask you to actually provide for at least permanent guardianship in your home will, and whoever is the guardian will show up with that particular will. But to be safe, you should do a DIFC will just to cover your 2 younger children. Okay.
Okay. And is there another question that's popped in? Oh, yeah. Okay. All right. Cynthia, thank you very much for your participation and your time today. That's been absolutely fantastic to do the presentation with you. I think